Joseph or Jay Ranney has been an adjunct professor at Marquette University Law School since 2000, and he's been the Adrian Schooney Fellow at the law school since 2014. In 2020, Jay retired from DeWitt LLP, where he practiced for many years, primarily in the areas of commercial intellectual property and civil rights litigation. He's the author of a number of books and articles on Wisconsin and American legal history, including Trusting Nothing to Providence, A History of Wisconsin's Legal System, In the Wake of Slavery, Civil War, Civil Rights, and the Reconstruction of Southern Law, Wisconsin and the Shaping of American Law, The Burdens of All, A Social History of American Tort Law, and most recently, Bridging Revolutions, The Lives of Chief Justices Richmond Pearson and John Belton O'Neill. He's currently working on a history of civil rights law in the northern and western states from colonial times up to 1968. So thanks very much, and you go ahead.
All right. Well, thank you, Craig. Thank you, Margot. And thank you to WJI for having me. It's an honor to speak. I particularly appreciate the opportunity because, as Craig mentioned, I'm currently kind of messing around with a project to talk about the hidden civil rights history of the North. I think among legal historians, the Jim Crow era, the legal history of race discrimination in the South has been exhaustively covered, but the history of civil rights in the North is more of a hidden legal history. And I think it's been subject to changing conceptions or changing misconceptions, if you will, over the years. I think at least for much of my lifetime, we kind of had a sense in the northern states that we were more virtuous, we were more racially righteous than people in the southern states. I think in recent years that started to change. I think we've seen that warts on our very complicated racial history grow just as profusely in the North as in the South. But I would put it to you that the history in the North is a complicated one, and I think it's one which I hope, if nothing else, you leave with nothing else out of the talk today, you will get a sense of how complicated it is, and it provides some insights which I think are useful for the current situation that we are in, where it will show how humans have to, judges, lawmakers, lawyers have to make very complicated decisions driven partly by reason, driven by partly human emotion. And I would like to think, as Dr. King once said, that the arc of history is long, but it does bend toward justice. So to give you a little flavor of that, I'm not going to try to cover the entire history of Northern civil rights law, but I want to cover the initial chapter of it today, or one of the early chapters, and I've entitled the talk Sumner's Children, named after Massachusetts Senator Charles Sumner, who I'll mention in a minute. And I want to talk about particularly segregation laws and segregation practices in the mid-19th century northern and western states, and talk a little bit about how those evolved. So first of all, segregation was unfortunately very common in the northern states in the first half of the 19th century. The only places that were largely free of segregation were the very northernmost parts of New England, Maine, New Hampshire, Vermont, and that was basic in large part, I think, because there were almost no African-American people there, so there just really wasn't an issue of whether there should be separation or not. Unfortunately, further south, in places that we think of havens of civil rights, such as Massachusetts and Connecticut, that was not so much the case. Schools in particular were almost uniformly segregated up until the mid-19th century. In Connecticut, at one point, kind of an interesting story, a lady named Prudence Crandall tried to start an integrated boarding school in Canterbury, Connecticut in the 1830s. She was met with a crowd that tried to drive her out of town. The Connecticut legislature passed a law in response, basically prohibiting integrated schools. She took her case to the state Supreme Court, won there. The law was repealed later on, but it is kind of illustrative of the fact that even in New England, it was not nearly the racial haven that it has sometimes been made out to be. So with that, I want to talk a little bit about what abolitionists and African-American community leaders did in Massachusetts to try to develop the nation's first anti-discrimination laws. And it all started basically with a movement to try to desegregate the Boston schools. In the mid-1840s, a community leader, a Black leader named William Nell, worked with Charles Sumner. Sumner at that time was a young up-and-coming lawyer in Massachusetts. He was a protege of Joseph Story, who basically founded Harvard Law School and served for many years on the U.S. Supreme Court. Sumner was decidedly of abolitionist sympathies, so he teamed up with William Nell to try to bring a lawsuit to desegregate Boston's schools. They found a school parent named Benjamin Roberts, whose daughter Sarah was forced to go to Boston's single Black elementary school, which was a long walk for her. She had to walk past several all-white neighborhood schools to get to her school. So Sumner, on behalf of the Roberts family, brought the case of Roberts versus City of Boston in 1850. And the case is important for a couple of reasons. One of the reasons is Charles Sumner, as we will shortly see, is indisputably one of the leading civil rights figures of the late 19th century. He becomes a U.S. Senator shortly after the Roberts case is decided, and he spends most of his 25 years in the U.S. Senate fighting for a vision of civil rights that was very advanced, even among liberal whites for its time. In some ways, is still very advanced in America today. Sumner actually took a step forward from what had been traditional abolitionist arguments, which relied on the Equal Protection Clause of the U.S. Constitution. Abolitionists had traditionally thought of whether segregation harmed Blacks. They didn't really consider the idea that segregation was an incident of caste, something, in other words, that damaged children of all races by denying all of them the opportunity to mix with each other so that they could prepare to live in a very diverse American society. Sumner fleshed out these arguments, which would later become a staple of abolitionist thinking, in his oral argument to the Massachusetts Supreme Court in the Roberts case. I put up a couple of quotes here. He relied first on a traditional equal protection argument. He did not rely on the U.S. Constitution because the U.S. Supreme Court under Roger Taney was a few years away from deciding Dred Scott, not very sympathetic to notions of racial equality. So Sumner relied on the Massachusetts state constitution, which contains a provision in his Bill of Rights stating that all men are free and equal. So he made the argument segregation violates the Massachusetts equal protection provision, which should be construed more broadly than the federal constitutional equal protection provision. And he also made the argument that segregation inflicts upon Blacks the stigma of caste. He did make the point it injures both races. It tends to create a feeling of degradation among Blacks and prejudice and lack of charity and kindness among whites. Unfortunately, Sumner and his clients lost the case. It was decided by the gentleman who is shown in the lower right corner of your screen, Chief Justice Lemuel Shaw. Shaw is one of the most important figures of 19th century American legal history. He made fundamental reforms in American tort law and a number of areas of law not related to civil rights. He also decided an important civil rights case in the 1830s, basically saying that if any slave or any African-American who was not free reached Massachusetts soil, they instantly became free. Quite a radical doctrine for its times. Unfortunately, he was not so progressive in the Roberts case. He said basically, we cannot use the Equal Protection Clause to kind of change what has been a longstanding policy of segregation, longstanding social custom of segregation in Boston. Shaw says, as the quote on the screen shows here, that the Equal Protection Clause is meant only to be an exhortation to legislators. Prejudice, he says, is not created by law, probably can't be changed by law. Segregation is a fair question for local authorities to decide. We will hear in future years Shaw's arguments, like Sumner's arguments, repeated over and over. The history of Northern desegregation efforts throughout the 19th century is marked by a fair number of judges who basically say we cannot use the law to change social customs. That can only be done by changing individual Americans' hearts and minds. There is, however, a happy ending to this particular story. Nell and the Roberts family and Sumner do not give up. They push the legislature to eliminate segregation in the Boston schools. And in 1855, as abolition and anti-slavery sentiment are making progress in Massachusetts, the legislature passes a law prohibiting school segregation. I think the first law in the United States explicitly prohibiting segregation. All right, so fast forward past the Civil War now. As I said earlier, Sumner is elected to the U.S. Senate in 1850. He spends the next 25 years of his life fighting for equal rights. He is one of the leading voices for civil rights during Reconstruction. There is a big debate during Reconstruction throughout the North. Should newly freed slaves be entitled to one, basic civil rights, which in that day just meant a narrow set of rights, including the right to travel freely, the right to own land, the right to have equal access to the courts, the right to be free in the employment that you chose, things like that. Most people in the North agreed, yes, that's part of what the Civil War was all about, that all Blacks should have basic civil rights. Political rights is the second thing that is discussed. That is much of what the battle during Reconstruction is about. You all are probably familiar with the 15th Amendment, which basically said that voting rights cannot be discriminatory based on race. That was kind of the culmination of a long struggle, which took place at the state level in many states, including our state, as to whether African Americans should have the right to vote. A handful of northern states did give Blacks the right to vote before the 15th Amendment was passed. Wisconsin had kind of a weird history. We had a referendum in the state in 1849 in which a majority of those who voted on the issue voted to allow African Americans to vote, but because the referendum did not receive a majority of the total votes cast at the election, it was a general election, everybody thought, well, the referendum failed. But in 1866, the Wisconsin Supreme Court, in a case called the Gillespie case, said, no, it didn't. A majority of those who voted on that particular issue was good enough. So it turns out African Americans had been allowed to vote in Wisconsin since 1849, although de facto they didn't get to vote until the 1860s. Anyway, back to Charles Sumner and Congress. After the civil rights and political rights debates were thrashed out, the remaining question was the third prong of civil rights, which was called by some public rights and by some the issue of social equality. That involved the issue of whether proprietors of establishments open to the public, theaters, restaurants, hotels, and the like, should be allowed to segregate if they wanted to, or whether social rights, civil rights included the right of free access to all places that held themselves out as open to the public. In 1870, Sumner introduced a bill in Congress designed to create what would become the last great civil rights law of the Reconstruction era. Sumner's bill was very broad. It said that denial of equal access would be prohibited to pretty much any public place, transportation, hotels, even cemeteries, and particularly, and very controversially, public schools. There was a long debate in Congress about that. Many Republicans in Congress, even though Republicans controlled Congress at the time, many were of a very divided mind as to whether civil rights should be extended to include social equality. Matthew Carpenter, who was then a Republican senator from Wisconsin, posed the most serious objection. Just a quick note here. I would suspect there's nobody in the audience today who has ever heard of Matthew Carpenter, which is a shame because he is an important figure in American legal history. He was one of the leading Supreme Court lawyers of his time. He, for example, represented Myra Bradwell, arguing that women should be considered citizens under the 14th Amendment and therefore should be allowed to practice law. So he kind of was on the side of progressivism in that case. Here, though, he was more cautionary. He pointed out during debate that, well, there's a problem. Sumner is trying to pass this bill under the authority of the 14th Amendment, but I've got the relevant language on the screen here. Basically, the 14th Amendment is directed at state action. It only prohibits states and state authorities from enforcing any law that abridges privileges and immunities of citizens of the United States and prohibits them from denying equal protection. So Carpenter basically said, well, I am sympathetic, Senator Sumner, with your goals, but the problem is you are trying to regulate the behavior of individual business owners, and the 14th Amendment only extends to state behavior. So that's a big problem. Nevertheless, Sumner and his supporters charged ahead. The debate continued for a long time, though. The bill underwent literally almost 5 years of debate before it was finally passed. A lot of centrist Republicans whose votes were necessary to pass the bill felt that Sumner's bill went too far. There was particular controversy over whether it should outlaw school segregation. There were fears that if it did so, there would be a massive negative reaction in the southern states. They might very well choose to shut down their public education systems altogether rather than allow Black children to attend schools. So the debate went on, and in 1874, the climactic debate came. So we're now 4 years into debating the bill at this point. I want to just briefly introduce you to another forgotten, but I think crucially important figure here. One thing that struck me as I've done my studies is there were a number of very important Black lawmakers and Black leaders during Reconstruction. They are hardly known today. That is going to be a very fertile field, I hope, for historians in the future, because there are a lot of great, dramatic, important stories to be told out there. And one of those stories is from a South Carolina congressman named Robert Elliott. Elliott, during the debate, gave a speech in favor of Sumner's bill, which I would recommend it to everybody if you are into studying great speeches. I think it is one of the great speeches of the 19th century, not perhaps quite on a level with the Gettysburg Address, but very close, and certainly on a level with speech makers such as Daniel Webster. Elliott made a lengthy argument. His legal points were basically, he relied on the U.S. Supreme Court's, at that time, recent decision in a case called the Slaughterhouse Cases, in which the Supreme Court said that the object, the purpose of the 14th Amendment was to protect newly emancipated slaves who, under the 14th Amendment, are now citizens, from all those oppressions of those who had formerly exercised unlimited dominion over him. Elliott argues that this language means that the 14th Amendment gives Congress the power to outlaw all vestiges of social inequality. He basically says the 13th Amendment, as interpreted by the U.S. Supreme Court, prohibits badges of slavery, and segregation is a badge of slavery. So Elliott's basically arguing, hey, both the 13th and the 14th Amendments prohibit segregation. Another person who spoke is another Republican congressman named Benjamin Butler, another long forgotten but important and interesting figure. Butler is white. He is a general during the Civil War. Those of you who are Civil War buffs may remember him most famously. He was the commander of New Orleans after the Union forces occupied it. And when New Orleans women insulted Union soldiers on the street, he issued an order saying that any woman hereafter insulting Union forces shall be liable shall be considered to be a lady of the street and shall be subject to treatment accordingly. That never happened, but it kind of gave Butler a reputation for notoriety. The reason he's important here, he launches a second political career after the war. He's in Congress, and he is the leader in the House of Representatives in getting Sumner's bill passed. And what's interesting about his speech during the 1874 debates is he kind of gives some insight into why white Republican radicals were so adamant in supporting social rights. A lot of it came out of wartime experience. War was a transformative experience for many white soldiers. It basically caused many of them, particularly those who fought alongside Black troops, to pretty much overnight discard their pre-existing prejudices about African Americans. And Butler describes a battle in which he commanded Black troops during the war, and says, from the time I saw their sacrifices, all prejudice was gone, and an old-time states' rights Democrat became a lover of the Black race. And he said, as long as their rights fall short of total equality, I am with them against all comers. So very eloquent speeches by both Eliot and Butler. The debate goes on, and things finally come to an head in early 1875. The Republicans have a very bad year in the 1874 elections, right at the end of Reconstruction. They lose control of Congress, and when the current Congress, which will end in March 1875, is over, that is going to be the last of any further Reconstruction legislation, because at that time, Democrats, there's no way they're going to allow any kind of laws that promote racial equality. So the Republicans use their last couple of months in power. There is some hasty behind-the-scenes deal making. Eliot and other Black congressmen basically say, look, we'd rather have a half a loaf than no loaf. So they could basically say, look, the two hot button issues here are cemeteries and schools. If you want to take schools and cemeteries out of the civil rights law, that's fine. We will, at this point, we will take what we can get. So those two things are excised, and the bill then passes and is signed into law 2 days before the last Republican Congress adjourns forever. All right, so here we are in 1875. We have the federal civil rights law on the books. So how is that going to work? Well, for a few, it's immediately challenged as unconstitutional under the 14th Amendment. Senator Carpenter's argument is resurrected, basically saying that the 14th Amendment only prohibits discrimination by the states, not by individuals. So the law is briefly enforced. There are a few cases where Blacks actually use it to obtain their just rights, but the case makes its way very slowly through the court system, finally is ready for decision by the U.S. Supreme Court in 1883 under the highly ironic name of the civil rights cases. And in the civil rights cases, Congress strikes down almost all of Sumner's 1875 civil rights law. I've put up on the screen here just a thumbnail sketch of what each side's reasoning is. It's an 8-1 decision. John Marshall Harlan, who is in the lower right corner there, is the lone dissenter. The majority basically does two things. It accepts Carpenter's argument that the law is unconstitutional because it goes beyond restriction of state action and it tries to reach individual action. The court also addresses Robert Eliot's argument that segregation is a badge of slavery and is therefore outlawed under the 13th Amendment. It basically construes the 13th Amendment in a very narrow way. It says, yes, badges of slavery are outlawed under the 13th Amendment, but what are badges of slavery? Well, says the court majority, they include only the basic civil rights that we talked about earlier: the right to travel, the right to marry, the right to own property, the right to work for whom you please, and access to the justice system. It does not include the right of access to theaters, hotels, other places open to the public. The one thing that civil rights advocates do get as a small victory is the 1875 law prohibits discrimination in jury selection. And the court says, yes, we are going to uphold that part of the law. Racial discrimination in jury selection is state action and therefore is reachable under the 14th Amendment. Harlan, in a very blistering dissent, basically says a couple of things. He says the majority is wrong and Eliot is right. The 13th Amendment's badges of slavery does cover segregation in public places. And he also says the federal privileges and immunities, which are protected by the 14th Amendment, are not limited to basic civil rights. They include all rights enjoyed by white citizens. In other words, Harlan's belief is under the 14th Amendment, if white customers are allowed into a theater or a hotel or another public place, Black customers must be allowed to, period. Okay, so here we are in 1883. The civil rights case is sort of symbolic. The Reconstruction era is over now. We're entering the Jim Crow era in the South and an era of what appears to be, I think what most students of history think is a period of total indifference and neglect in the North. And we now have a case where the 1875 Act, which was Sumner's and the Civil Rights Movement's great hope for true racial equality, kind of lies in ruins at the hand of the court. So what happens next? Well, here's where we come to a not very well-known part of civil rights history in the northern states, which I think should be much better known than it is, and I hope I can convince you all of that in this talk as well. First of all, what was the reaction to the court's decision in the civil rights cases? Well, as you might expect, white Northern Americans are largely indifferent. I put a quote up here from The Nation magazine, which back then was a lot stuffier and more conservative than it is today. It was kind of one of the bulletin boards for the Northeast Corridor white elite to share their thoughts with one another. And The Nation observed basically, they went back to Lemuel Shaw's argument of, well, you know, social equality is not something we can legislate. It's something that has to be won by changing the hearts and minds of white Americans. The Nation says the court's decision shows how the extravagant expectations of the war and Reconstruction have died out. And it says basically the decision came about and Sumner's Act failed because social equality has not come distinctively into view. And by that, of course, the Nation magazine means it has not come distinctively into view for most American whites. There is an uproar, as one would expect, in the Black community. Frederick Douglass, there's a mass meeting in Washington. Douglass speaks at the meeting, denounces the decision as a concession to racism, selfishness, and meanness, which will be received with joy by every upholder of caste in the land. Note how he is in sync with Sumner, saying segregation is not just a matter of race, it's not a matter of discrimination purely against Blacks, it's a matter of caste. It hurts all Americans. A federal prosecutor responds to arguments that, well, you know, the law, nobody ever really used the law anyway. He says that's not true. The necessity of the law is established by the cases in which Black litigants have prevailed, and we need more of that. So what happens next? Well, here's where we get to the unknown but very important chapter of American law. Immediately after the Supreme Court issues its decision, a number of states throughout the North passed their own civil rights laws, or what I call accommodations laws. The civil rights case, remember, talks about the 14th Amendment. The 14th Amendment is a restriction only on what the federal government can do. The federal government is not empowered under the 14th Amendment to go after private discrimination, but under our federal system, the states basically have any residual power that is specifically denied to them under the Constitution. And the 14th Amendment doesn't deny the states the right to enact anti-discrimination laws. They can do so if they want, and a number of states do. So why did they do this? I should say it starts out almost immediately. In the first session of the Ohio legislature in 1884, Ohio becomes the first northern state to pass an anti-discrimination law. Now, here's the question. Ohio is a state that's very close to the South. It's almost a border state. You've got a lot of people who came from, a lot of whites in Ohio who came from the South. Ohio is largely a Republican state, but it's very closely divided. The Democrats and the Republicans kind of trade election victories back and forth. So the Republicans by no means dominate Ohio. So why is it the pioneering state? Well, I think there are several reasons, but the most important answer is provided by a newspaper quote from the then president of Howard University, William Patton, who points out, well, blacks have the right to vote now, and there are 1 million colored votes distributed throughout the northern states. In many of those states, the political parties are nearly balanced, and those votes will not long be unheeded. So in Ohio, the Democrats in Ohio by this point talk among themselves. They also talk with the gentleman whose picture is on the screen here, Peter Clark, and they come to the conclusion that, you know, blacks have the right to vote under the 15th Amendment. We just have to accept that the Civil War is over. So how can we pragmatically take advantage of that? And the way we can take advantage of that is we have to compete for the black vote now. Ohio's black population has the potential to spell the difference between victory and defeat for the Democratic Party in Ohio. So let's go along with the Republicans in enacting an accommodations law here. Peter Clark is yet another. I said earlier, there are many fascinating stories of little known African-American figures during this period. Peter Clark is one of the most interesting stories. Clark is kind of a temperamental radical all his life. He's born into slavery, comes to Ohio as a young man in the late 1820s, and spends most of his career trying to fight for a black school system in Cincinnati, his hometown. This is before Ohio desegregates its schools. He becomes a leading figure in Ohio Democratic politics. He at one point goes with the Democratic Party after the war thinking, well, you know, most blacks are siding with the Republicans. I can probably have more of a voice if I go with the Democrats. So he joins the Democrats for these tactical reasons, talks to the legislators behind the scenes, and it's really not much of an exaggeration to say he is more responsible than anybody else for the passage of the nation's first anti-segregation law, the first public accommodations law. I say first law, that's not quite accurate. There were earlier laws passed in Massachusetts right after the Civil War and in New York and Kansas during Reconstruction. New York's another example of how the two parties were very closely divided, and the Democrats in New York, like Ohio Democrats, decided that their best political prospects would be if they tried to court the black vote by supporting accommodations laws. So anyway, in 1884, Ohio passes the first of what I call the Sumner's Children laws, the accommodations laws passed at the state level in reaction to the Supreme Court's striking down of Sumner's law. The Ohio law is a typical example of the formatting of an accommodations law. If you see there, it's got a laundry list of places where discrimination is specifically prohibited. It includes restaurants, eating houses, barber shops, interestingly, public transportation, but then it also has right at the end there what I call an omnibus clause. And it says, and the law covers all other places of public accommodation and amusement. This is very typical of many of the laws of the late 19th century. Some laws will have a laundry list of places where discrimination is explicitly prohibited. Others, and some will not. Some will have an omnibus clause only. Some will have both. We don't have time to go into it today, but there is an extensive body of court decisions in the North throughout the late 19th century interpreting these provisions. For example, all other places of public accommodation and amusement. Does that include public bathing houses? Does it include amusement parks? Does it include shoe shine stands? All sorts of places come up, and the decisions are all over the place. Some state Supreme Courts interpret the laws very narrowly. Some laws interpret particularly the omnibus clauses very broadly to expand the boundaries of anti-discrimination. It's a very interesting aspect of Northern civil rights law in general is the course of interpretation of these laws in the cases of the late 19th and early 20th century. They do provide kind of an interesting window into the ebb and flow of racial sentiment among Northern whites during that entire era. So the trend goes on, and I've got a map here to show you by the end of the 1880s, all of the states in blue had anti-discrimination laws. There were only a few holdouts, mostly in the West, where anti-Black sentiment, anti-Asian sentiment was quite strong at this time. The states in Northern New England, which I think didn't pass anti-discrimination laws because they simply didn't feel the need to. There wasn't any de facto discrimination to speak of. So that leaves Connecticut, Pennsylvania, and Wisconsin. We get around to passing an anti-discrimination law eventually. I'll talk about that in a minute. We're a little bit slow, but we and the other blank states here in the East all get around to passing anti-discrimination laws eventually. We pass one in 1895. Connecticut passes one in 1905. Pennsylvania passes one under heavy pressure from the Black community. This is another state that's pretty evenly political balanced in 1887. So I would put it to you that the discouragement and gloom that followed in the Supreme Court's decision of the civil rights cases in 1883 is followed by what amounts to a very quiet but nonetheless substantial wave of reaction in the northern states. Most states are saying if the federal government is not going to protect Blacks from discrimination in public places, we will. All right, well, I'd like to conclude today just by talking briefly about the story in Wisconsin. We like to think of ourselves as racially progressive. We have, I guess, what I would call, we never really had a Jim Crow era as such, but we were certainly not in the forefront of civil rights reform, unlike states like Massachusetts. Robert Nesbitt, who wrote a leading general history of Wisconsin, summed it up pretty well, I think. By the end of the 1800s, the Black population, which was about 0.5% of all Wisconsinites at the time, was not overtly discriminated against, but they were, as Nesbitt says, treated with paternalism, with indifference, sometimes with hostility. He says there was a cold and formalized pattern of race relations. Blacks were amusing in their place was the message. This is probably typical of a lot of the Midwestern and Western states at this time. There are a few ugly incidents of overt discrimination. It's deplored by a lot of people, but it is not illegal at this time because Wisconsin doesn't yet have an accommodations law. In 1886, Frederick Douglass, while on a speaking tour, stops in Janesville and is refused entrance by a Janesville hotel. In 1889, there's another racial incident at a place called the Bijou Theater in Milwaukee. The Bijou Theater no longer exists. It was roughly where the Pabst Theater is located now. But a Black Milwaukeean goes to the Bijou, asks for a ticket. He is told you can have a ticket, but you have to sit in the Blacks only section in the balcony. He says, no, my civil rights allow me to sit anywhere that my ticket is good for. He's thrown out of the theater, but he then files a lawsuit against the theater owner, being represented by this gentleman here in the upper part of the screen, who is William T. Green, Wisconsin's first Black attorney. Green and the theater patron win their case. The following year, Daniel Johnson, who's a Milwaukee circuit judge, rules against the theater owner. We don't, unfortunately, have a copy of his decision. We just have newspaper accounts from the time. Johnson basically relies on Wisconsin's state equal protection clause. That's interesting given the fact that the U.S. Supreme Court has said for the federal clause, no, the federal equal protection clause doesn't cover social equality. So Green and another lawyer, Jerry Hazelton, who is from Madison, get together and they continue the battle. Why does Hazelton get involved in this? Well, because during Reconstruction, Hazelton was a congressman. He was an active participant in the debates over the Sumner Bill. In 1890-91, he's back in Wisconsin practicing law, but the old civil rights fire is rekindled in him, and he agrees to help Green and Green's client out. In 1891, they go to the Republicans in the legislature and introduce an accommodations bill. However, they run into roadblocks. At this time, the Democratic Party controls the legislature and is still fairly hostile to this type of legislation. Hazelton and Green offer to amend the bill so it's limited to hotels and inns only. The legislature goes along with that, but the bill then dies in committee and never gets enacted. 4 years later, the Republicans regain control of state government. A new accommodations law covering many more things than inns and hotels is introduced, and it's quickly passed. So finally, in 1895, Wisconsin gets a formal accommodations law. Now, the next question is, all right, so what is the Supreme Court going to do with Wisconsin's omnibus clause and its laundry list of things? Is it going to engage in narrow construction, saying, no, the law only covers items specifically enumerated and very similar items, or is it going to interpret the law expansively? Two decisions, one in 1897, the Bryan case, one in 1908, the Jones case, make it very clear that the court is going to err on the side of broad construction. The Bryan case involves a restaurant discrimination case. The Supreme Court not only holds that the law applies to restaurants, but says that the restaurant owner cannot get out of liability by saying, well, I never authorized that. It was my employee that did it. The Supreme Court says, under vicarious liability, if your employees practice discrimination, you're liable. You don't get out of it that easy. And in the Jones case, interesting, it involves a roller skating rink. Roller rinks, very popular in the United States at this time, but they're not listed in the Wisconsin accommodations law. But nonetheless, the Supreme Court interprets the accommodations law broadly and says, yes, this law extends to roller rinks. So that ends with that story, we'll end our discussion of the 19th century phase of civil rights law in the northern states, including in Wisconsin. I guess a couple of lessons just to leave you with from this today. Number one, this kind of illustrates to me one of the central themes of my scholarship has been people should study state law and social developments as reflected in state law at the state level, not just focus on the federal courts and the U.S. Supreme Court, as most scholars and most of the media tend to do. There have been some very interesting developments in the states over history, not least among them the movement in the northern states to enact accommodations laws in response to the U.S. Supreme Court's decision. I think the other lesson to take from this is the history of civil rights law in the North is complex. As I said at the beginning, you've seen how conservative many judges were. You've seen how African Americans in the North as well as the South had to struggle against pervasive de facto discrimination in their daily lives, sometimes openly authorized by law. The struggle was long. They had to fight against the U.S. Supreme Court. They had to fight against the constitutional arguments of Matt Carpenter, and they had to fight with judges who were inclined to interpret accommodations laws narrowly. We are a long way from racial heaven by the end of the 19th century. We're still a very long way from racial nirvana today, but the lesson I would like to take, putting an optimistic gloss on our history is that in the 19th century, the path toward equal rights, the arc of justice took a twisting path. There were setbacks, but slowly over time, with much patience, things did get better. So I will leave it at that, and I would just urge all of you who hopefully this has sparked some interest. The story goes on well into the 20th century, and if you are so inclined, there are books to read out there on various aspects of this, and it makes a fascinating history, not just a legal history, but social history, one that all Northerners, really all Americans, should be more familiar with. Thanks very much, and I'd be happy to take questions.
All right, thank you, Jay, very, very much for that. And for those on this call today, this talk ties into WJI's Unsung Heroes series that we've been doing in the blog for the last few years. And in fact, I'll put some links in the chat. We've done a blog post about Ezekiel Gillespie, who is mentioned in the presentation today, as well as William Green. So we have some, short kind of history on those two men, and I'll put links to that in the chat. But we also have a lot of other women and people of color that we think have not had their stories told sufficiently regarding Wisconsin legal history. So let me open it up to questions, and Dorothy Dean has indicated she has one. So go ahead, Dorothy.
Thanks. Yeah, I really appreciate this presentation because I have so little time for reading. And now I know I got to put this book on my list. I am asking about some of the things that I've been hearing for the last couple of years at the local level. And I'm concerned about the Supreme Court, the U.S. Supreme Court, looking into segregation segregation in education. I think I'd like to ask about that first and then mention the local, but I have been hearing a lot about taking a look at the separate but equal protections that Brown versus the Board of Education gives to, I guess, well, I'm not a lawyer, so I don't have the right words. You can fill in the blanks, I'm sure, but I have been hearing that they're going to do that, and I'm concerned about what the application might be to the Americans with Disabilities Act, for one. Right now, I have a letter from the former secretary of the Department of Safety and Professional Services for the state of Wisconsin that says very clearly that the department will take the needs of disabled people into consideration in a different way from the way everyone else is treated. And what that means is they're undercutting the ADA. Now, I've heard it also at the local level. The local level is less likely to do something in that regard, but the eugenics problem is something that also has come up at the local level. I think there were still laws on the books about that in some states, maybe only one or two until the 60s. And it may have even been later than that. And I'm very concerned about how that's going to affect, if it's going to affect at all, what happens with the Americans with Disabilities Act and any premises that are based on laws that are not specifically for people with disabilities, but are for, like the eugenics law, which was applied to people with disabilities. So I guess that's it. And if you can comment on that, that would be really wonderful.
Yeah, you covered a lot of ground there. Let me see if this is helpful to you. So one of the reasons I think that the accommodations laws of the 19th century hit a comfort level for a lot of white Americans in the North was that they were not perceived as conferring special treatment on African Americans or anybody else. They were perceived as kind of leveling up laws. They just said they didn't say anything about preference. They just said there shall be no discrimination. And that has kind of been I didn't talk about the 20th century, but I can tell you that has been a continuing theme in the 20th century, in Brown versus Board of Education and well before. The reason that I've cut my study off at 1968 is I think my conclusion from what I've read is that by 1968, you had the great federal civil rights leveling up laws in place. You had the Civil Rights Acts of 64 and 65, which basically said federal level, we can now, we are now enacting another federal anti-discrimination law. By the way, they didn't base it on equal protection. They based it on the Commerce Clause, which is, ironically, Matt Carpenter had suggested that legal hook 100 years before. And you had the Equal Opportunity Housing Law in 1968. So by that time, really, federal law provided for, quote, equal opportunity in pretty much every walk of life. Many state laws enacted in the early 20th century did the same thing. But we've now, I think since 1968, the debate has fundamentally shifted. I think everybody, just about everybody on all sides of the political spectrum accepts in principle the idea that we must have equal treatment. But the problem is, where do you draw the line between equal opportunity and preference? That debate is being manifested in a number of different ways, the debate over affirmative action, and really the debate over whether African Americans are owed some kind of reparation. The debate, put another way, the debate currently is should we recognize that people through history, through no fault of their own, are still disadvantaged, even though the laws may provide for equal treatment going forward? And is it appropriate constitutionally, socially, morally to do something about that, or is it inappropriate? So I think, Dorothy, I don't know if this is going to be a real satisfying answer, but I think the best I can say is that I don't think anybody is disputing, talk about disabled Americans, that they are entitled to equal treatment. I think I'm optimistic most people today, even though there are some challenges, most people would say a reasonable amount of accommodation must be given to disabled people in order to make their equality of opportunity meaningful. But the debate is, how far do you go there? And I agree with what I thought I heard you say. That's now becoming a matter of debate with an intensity that it did not have for much of the late 20th century. I hope that's helpful. Kind of a long rambling answer there.
I think I would tend to disagree with some of what you said.
Okay.
Actually. But I don't know. Do you have time, Margot, or not?
Well, I'd like to see if some other people have questions first. Maybe Jay, are you okay if I give Dorothy your email address and she can contact you? Okay. All right. Any other questions from the group? Craig, go ahead.
Thanks. Fascinating talk. Thank you so much. I'm wondering if you could expand a little bit on sort of the intersection between, if you're able, in sort of Wisconsin partisan political history and these attempts to reach racial equality. I noticed that, and obviously the Republican Party is a party that was in many ways, its genesis was its opposition to slavery, and you point out in 1895 they were the people that gained control of the legislature and passed this anti-discrimination law in Wisconsin. How did the partisan aspect of it play out with the sort of La Follette progressives and the Democratic Party, particularly after the 1940s, when it sort of was in a sense reborn in Wisconsin political history? How did that play out in relation to these progressive policies on racial discrimination laws.
Sure. I'll do a real thumbnail sketch here. So they're really the progressive era was kind of an era of civil rights inactivity in Wisconsin. The progressives did a lot of things. They had a lot of priority items on their punch list, but furthering civil rights was not one of them, not because they were necessarily racist. It just really wasn't on their radar screen. The main advances that came during the progressive era and during the years after the progressive era were changes brought around by community activists. The main one was there was another Black lawyer in Milwaukee named George DeReef, who went on a crusade to try to get more Blacks on Milwaukee County juries. Milwaukee County, unfortunately, up to 1915, had a kind of a policy of systematically excluding Blacks from jury panels. Reef went to them and basically said, look, under, ironically, the civil rights cases, you can't do this. We have to have equal opportunity. And the Milwaukee County authorities said, yeah, you're right. And some progress was made in getting more Blacks on jury panels. Other than that, the main social thing was African Americans start to come into Wisconsin in significant numbers for the first time in the 1930s, 1940s. There were always small Black communities in the major Wisconsin cities, but the Black population really did not have a significant numerical presence until, I would say, the 1940s, 1950s, when you had the second Great Migration, African Americans coming north during World War II in particular to work in defense plants. As far as the modern era of civil rights, I would say Democrats were a little more inclined to advance the ball on civil rights in Wisconsin from 1960 forward, but there really wasn't the deep partisan divide over that you saw in other parts of the country. Republicans in Wisconsin in the 1960s, 1970s were, hope I don't get in trouble for getting too political here, they were considerably more moderate than they are today, and they went along with when civil rights reforms came about, they went along with them. But really, again, progress in the late 20th century was achieved more at the community action level than it was by some pitched political battle in the state legislature. For example, the movement to desegregate Milwaukee schools, that didn't come about by battles in the legislature so much as by the Lloyd Barbie, who headed at that time the Milwaukee branch of the NAACP, working to desegregate the schools and working with Father Grappi and other community activists to bring racial divides in Milwaukee to everyone's attention.
Thank you.
Today we have a question from Gretchen, whose sound and video haven't been working right, but she asks, where does the current U.S. and in Wisconsin Supreme Courts fit in with the context of the cases you discuss?
That's a good question. It was kind of all right. I talked a little bit about the two cases in which the Wisconsin Supreme Court liberally interpreted the accommodations law. I think other than those two, there haven't been that many landmark racial civil rights cases decided by the Wisconsin Supreme Court. I think the one case, actually, the other case of any importance was a case in the mid-1950s, which actually was somewhat of a frustrating decision for civil rights activists. The deal there was, okay, at the end of World War II, Wisconsin passes a Fair Employment Practices Act. It prohibits racial discrimination in the workplace. And in the mid-1950s, a Black employee who feels that they are being discriminated against brings a lawsuit against their employer and seeks damages, and the Wisconsin Supreme Court says, sorry, we're throwing your case out of court because the Fair Employment Law doesn't provide a private right of action. Now, I think really, from a legal point of view, that was the correct decision, but it was a disappointing one. The good news there is a year after the decision came down, the legislature passed a law creating a private right of action under the employment discrimination law. But, you know, just finally, I think part of the question was, what about the current Wisconsin Supreme Court? Remains to be seen. I think the issues we're all looking at we're all waiting to see whether they will address, involve gerrymandering, perhaps Act 10 and abortion, which those all, one could certainly make an argument they have some indirect racial implications, but they're not what I would consider direct racial civil rights issues.
All right, we're a couple of minutes after 1, so I really want to thank Jay for the great presentation today. Super interesting to me with my history degree from undergrad. And I hope you all found it really interesting as well. And thank you, Jay, for taking the time to put together the PowerPoint slides and the detail that you've put in for today was just
My pleasure. Thanks
really
for
wonderful.
having me.
I want to say that our next salon will be on July 19th, and we'll have Assembly Representative Evan Goyke with us in person at the Riverfront Pizzeria in Milwaukee. And he'll be talking about expungement and criminal justice reforms that are possible in the legislature this term and how those are going. Look for a registration link for those probably beginning next week in our emails and e-newsletters, as well as on the events page of WJI's website. We'll have a lunch buffet of pizza, pasta, and salad as usual, but you can attend for free as well. Just let me know so I make sure we have enough chairs in the room. Thank you again all for joining us, and have a great afternoon. And once again, thank you, Jay.
Thank you.